Okay, 1 and 2. Okay. You have been saved for the last, so you have the wonderful time of just before lunch, right? That always inspires you, right? Make sure we stay awake, we're not suffering from any deprivation of caffeine or calories or the like. Counsel, did you wish to reserve any time for rebuttal?
Yes, Your Honor, 3 minutes, please.
3? Okay. And I'm sure based on past practices, that I will be your interrupter then around 17 minutes to let you know when you get there.
Yes, Your Honor, and thank you.
Okay. I want to make sure I do this right. Is the E at the end of your name silent?
It's Samoli. It is not.
Okay.
Samoli. Thank you.
Long E. Okay. Thank you much, counsel. I think I can do Purdy. I think I'm okay there. But today's been an interesting day with surnames, and as you might suspect, sometimes I'm a little sensitive to that. So let us begin.
Good morning. May it please the court. Bridget Chek-Samoli on behalf of the appellant, Doris Beatty. The trial court erred when it determined that the letter filed by appellant when she was a pro se was not seeking relief pursuant to Rule 1.540. The trial court also erred when it found that even if the letter was construed to be seeking such relief, the letter did not set forth a colorable entitlement to such relief, and therefore an evidentiary hearing was not required. Turning to the sufficiency of relief seeking pursuant to 1.540B5. This court in Bank of New York Mellon stated that for such relief to be available, there must be some new post-judgment fact or occurrence that requires the trial court in equity to recede from its prior order or judgment. Now, that fact or occurrence here that occurred post-judgment is the entry of an ex parte injunction that was entered after the judgments and after the settlement agreement, which the parties entered into. The settlement agreement that underlies the judgments is in which my client specifically gave up numerous rights, and those are set forth in the sealed appendix at pages 7, 10, and 11. And by giving up these rights as part of the settlement, she did receive other rights, and that's in the sealed appendix at 13. That includes reasonable updates from any guardian, which Mr. Beatty had. She was permitted to make recommendations regarding his health care. A landline phone would be set up to allow her to speak with him, and she was given reasonable visitation. But the entry of the injunction took away each of these rights, and that is the substantial and material post-judgment event that affected the equities of the underlying judgments and in turn the settlement in this case. Now, looking at this court's decision in Shivo, 792 Southern 2nd at 560, the entry of the injunction here was what the court in that case said, a significant change in circumstance. And that arose after the judgment here. And that made it, the entry of the injunction here made it inequitable for the trial court to enforce its order. And now
let me ask you to return to your first point.
Yes.
The agreement provides that the right to visitation may be terminated. So the ability to terminate is not necessarily new. It's incorporated in the document. Is that are we looking at merely temporal, or are we looking at the fact that this is new, that the right to reduce or eliminate her visitation existed and she contracted for it?
So Your Honor is correct that paragraph 11 does relate to visitation. Then this is part of the settlement agreement.
And to enforce paragraph 11.
Right. So it says this right to visitation may be terminated by the guardian if there's reasonable belief that's in, but there's a difference in what happened here and what was contracted for. The paragraph 11 does not contemplate my client ever losing the right to complete contact with him whatsoever. Now, she gained a number of rights in the settlement agreement. The injunction completely barred her from having any contact. There was no contact with the guardian. She was unable to provide input in his health care. If you look at the settlement agreement, paragraph 11, which is in the sealed appendix at 13 and 14, on page 14, as to the sentence Your Honor speaking of, that was a very limited statement. What is in the the ex parte injunction was quite broad. It took away all the rights she contemplated and that she bargained for. This was a complete evisceration of the bargain that she made in the settlement agreement and was very different than what is set forth here. This was a very limited loss of right. The injunction was a much greater loss of right.
Ms. Simone, wasn't the
Does-
injunction, I'm
Go ahead,
sorry.
please.
Wasn't the injunction imposed based on her own alleged conduct? And I know it's not a perfect analogy, but isn't it sort of like the person who kills his parents and then asks for leniency because he's an orphan? I mean, this was
Yes.
based on her alleged misconduct, and now she's saying it's inequitable to deprive me of the benefit of my bargain.
So looking solely at where we are procedurally, we are asking the court solely for the opportunity to have an evidentiary hearing. What Your Honor is addressing are points, defenses, and responses that would be appropriate at the time of the evidentiary hearing. What rule?
Well, I don't know if that's true, and I appreciate that argument, but if you look at what she says in her letter is basically, it asserts that this is inequitable because the whole purpose of the settlement agreement, my whole intent was to spend more time with the ward. So assume that there's no dispute about that. Assume that was her absolute intent. There's no factual dispute. But at the end of the day, the injunction was imposed based on her alleged misconduct. So unless it's going to turn into a hearing on the temporary on the injunction, what are the factual disputes here if we're just looking at the equities in terms of the final judgment and the settlement agreement?
The settlement agreement, well, first of all, the parties had some issues that are contemplated in the settlement agreement prior to. So this was not, there was already some statements put in place. The fact that it has been alleged that it was her issues isn't that it's the change of circumstance that we have to look at, Your Honor. It's not her causation. The causation, it's the law requires under B5, the change in circumstance. What is the change of circumstance? That was the taking away of the rights under the agreement. The fact is we're not at the point where we can weigh whether or not her actions are. Now, during the hearing at A135 and 136, we did lay out 7 different issues that would be discussed and addressed at the evidentiary hearing, one of which is the point that you are raising right now. And we state that the change of circumstance, the event itself, is what triggers the requirement of an evidentiary hearing. Anything that occurs or any basis, reasoning, response, or defense comes after that. We would look to this court's
Let me
decision.
ask you this. To get an evidentiary hearing, you have to establish a colorable claim?
Correct. It's a colorable
Okay.
entitlement
And
to
a
relief.
colorable claim, I think Judge Lazare, writing for our court in Blimpie, indicates 2 things have to happen. Your motion's not sworn to. Her motion's not sworn to, and there's not an affidavit that I could find the record in support of the motion. And what counsel says at the hearing is of no legal import. It is not a fact. It's not under oath. So it would appear on this record, you have failed to establish an entitlement to a hearing.
Your Honor, Blimpie, first of all, is a default case. And so factually that is distinguishable.
Yeah, but you relied on the 4th District, and there's been a lot of cases following that in order to get a hearing.
Your Honor.
And further, if you're going to do fraud, it has to be specifically set forth and identified. And I think Judge Atkinson recently wrote an opinion citing that at least in one part cited an existing case to do that. So as I look at the sufficiency of her letter, even if I take it as a motion, I'm looking for specificity of fraud, and I'm looking for evidence that triggers the right to a colorable hearing that gives you an evidentiary hearing. And if you have to have it sworn to, I'm having concern under Blimpie and all those cases that follow that you have not met the requirements.
Your Honor, I'm going to start with the verification point, and then I'll go into the evidence.
Thank you.
There is not an affidavit. Your Honor did not miss it. It was not sworn to, but we do not believe that the law supports the point that it is required to be verified. And what I would say is if you look at Rule 1.540, there are certain requirements of that rule. First, from points 1 through 3.
I didn't see a specific announcement that said it had to be sworn to.
And we
I've
know
only seen
that,
it in the case law.
and we know that when the rules do require verification, they expressly state it. Florida Rule of Civil Procedure 1.030, and it actually states that
Here's
should
what I'm concerned about in the logic of the position. Do you get an evidentiary hearing to support the need to have an evidentiary hearing? Because what you're saying is we would like to have in your, because at the record on page 121, counsel for the opposing side said, Judge, there was no sworn testimony, no affidavits. Mr. Greenberg responded, well, we only want to address whether or not we can have an evidentiary hearing. Well, to have an evidentiary hearing, you have to have a colorable claim.
Correct. And we laid out at 135 and page 135 and 136 of the hearing, the 13 facts and the
So we should take his laying out as the substitute for a verification.
It's not
Or a
his
functional
laying.
equivalent, or whatever you would, whatever term you think is appropriate. I'm not trying to put words in your mouth. I'm just saying
No, I
it's
understand.
supposed to be the same thing.
But Your Honor, here, what counsel was doing was taking the contents of a pro se letter and setting them out. We all know that pro se pleadings are to be liberally construed, and especially in the context of a Rule 1.540, where the court is to liberally construct as set forth in the Travelers commercial case from the first. Yes, Your Honor.
And that's correct, but I guess circling back to what Judge Casanueva asked Ms. Somoli, in terms of a colorable claim, if you look at the letter, she's making allegations of extortion, intimidation, things that happened well before this issue of the injunction came in. And so circling back to what Judge Yoakum has indicated, that if your client, by virtue of her actions, necessitated the bringing of this injunction, and then whatever happened in the injunction, and for her later on to use something that happened well before saying, well, I was extorted, I was intimidated, to get around that, how do you reconcile that?
So Your Honor is also what the trial court noted was that the trial court at A222 states that there are a number of concerns raised in the letter. And I would point the court to its Chancey decision from 2004, in which the court noted it set aside a denial of a motion for relief. And it said that even where the allegations setting aside are buried within numerous letters and motions and are not artfully stated, the trial court still must construe such pleadings to determine whether there is a colorable basis for relief. And here there is such a basis. While I recognize that the letter may not be as artfully stated as the trial court or this court would have wanted, the letter itself does request additional time with Mr. Beatty. The letter does request a role in coordinating his care and medical treatment, a hearing, a fair trial. And she talks about the effect of what she gave up in exchange for the, I'm sorry, Your Honor, yes. Oh, Your Honor,
My
you're
fault,
muted.
I'm muted.
Yes.
Is all that now mooted by his passing? All that
No.
extra time, relief, said, that was what the order was, and her standing in paragraph 11 was to enforce visitation.
Your Honor, we do not believe that the death of Mr. Beatty has caused a mootness issue. While it is true that was an aspect or important aspect of the settlement, under Florida law, and it's under the Goodwin decision, which appellees state, mootness is only when the controversy has been so fully resolved that a judicial determination has no actual effect. And that is not the case here. An appellate decision in Ms. Beatty's favor would restore her rights, and I mean an ultimate in her favor, just to be clear, not an evidentiary hearing, but an ultimate, would restore her rights to a pre-settlement position. As set forth in the settlement agreement itself, it lays out a number of non-visitation issues which she bargained away. And therefore, she would still be able to be put in a position where the parties would have to work out at that point. So no, the controversy is not moot, simply only because Mr. Beatty has passed, Your Honor.
I think the fact of her allegations that she was intimidated in signing this, and her whole point in providing that letter is based on the fact that she wants to spend more time with him. She wants to be part of his care. Doesn't stem from all of that, which then begs the question, isn't it in fact mooted by virtue of the fact that he did pass away?
I apologize, Your Honor. No, we do not believe that to be the case. In the letter, she does speak about the fact that she is looking to that the injunction has taken away the rights that she bargained for, but she does address a number of other issues in that. And so we believe that at the end of this litigation, if she were to prevail, the position she would be in would allow her to address a number of the points that she did bargain away at in the sealed appendix. Yes, Your Honor.
Isn't the injunction the only post-judgment event
That is
that would give rise to relief under 1.540? And if that particular thing is mooted, I mean, aren't you sort of using this moot issue to try to bootstrap your other claims in that are all pre-judgment?
That's the factor occurrence, which provides relief under B5, but it's not in such a way that we're then limited, because remember, we would go back to our pre-settlement position, which is a very different position. We're not going back to simply before the temporary injunction was entered. We're going back to the pre-settlement position. So the rights that we had at that time are very different than the rights at the time before the temporary injunction was entered.
So, and to follow up with that, let's just assume there was never an injunction to begin with. Set that aside. Okay, totally aside. Would she have any basis whatsoever right now to proceed?
We do not right now, based on the record that we have. It would be difficult for me to provide you with an example where we would. The temporary injunction is the post-judgment factor occurrence. It is what took away the rights that she had. Is it possible there could have been something? I don't want to speculate or try to use Your Honor's time to come up with something else, because the real right now, under the B3 and the B5 relief that the appellant sought in her letter, the resulting motion and memorandum are based on the post-judgment change of circumstance, which is the taking away of her rights under the ex parte injunction. Your Honors, if I could, I just wanted to be a little bit more specific as to what and this is at the appendix of pages 126 through 129, that she argued that we set forth that were the facts that are part of the record. To be clear, all of these facts are based in the record. And so that also is somewhat different than when you see these default cases where it is, based on things that happen. We are looking solely at the record. You're looking at the settlement agreement, which there is no dispute, there is a settlement agreement. You are looking at the judgments, the injunction, and you are looking at her letter. Those documents alone establish the basis for the relief. This is a pro se who filed a letter that she signed that set forth. Yes, Your Honor. You're just muted. I apologize.
You're at 17.
Okay. With that, I will, unless the court has questions for me at this moment, I will ask for the rest of my time on rebuttal. Thank you, Your Honors.
Thank you, counsel. All right, I'm good. Then I can tell counsel you may proceed.
Good morning. May it please the court. My name is Lauren Purdy on behalf of the law firm of Gunster, Yoakley, and Stewart, counsel for the appellees. The issue in this appeal is whether the trial court abused its discretion in finding that the appellant's letter failed to set forth a colorable entitlement to relief under Rule 1.540B3 or B5, and therefore no evidentiary hearing was required. The trial court's order correctly preserved the finality of the judgments entered below, as well as the settlement agreement executed by the parties over 2 years ago. And this court should affirm the judgment of the trial court for 4 reasons. First, the trial court correctly construed the letter as a response to Judge Stargill's imposition of the temporary injunction. It wasn't a Rule 1.540B motion at all. Second, the trial court correctly rejected the appellant's B3 argument, even assuming the letter was a motion, because it didn't state a colorable basis for relief under B3. 3, The trial court correctly rejected the appellant's argument that the mere imposition of the temporary injunction and the exercise of the court's equitable power to protect the ward from the appellant is somehow a post-judgment and equity justifying vacation of the judgment. And 4, appellant's argument in their brief that the trial court failed to consider the memo of law as its own Rule B5 motion for relief was first not raised until the appellant's motion for rehearing, which is the subject of a separate pending appeal whose briefing has not yet closed. And second, regardless, the record reflects that the court fully considered the appellant's B5 arguments. Now, first, as to the trial court's first finding, the letter clearly was not a Rule 1.50B motion for relief from the judgment under either B3 or B5. We agree with the appellant that a pro se litigant's filings are entitled to a liberal construction, but the court in James versus Cruz nevertheless recognized that even pro se litigants are obligated to follow the rules of substantive and procedural rules of law. And the court is not at liberty to redraft a filing in order to assist a pro se litigant, particularly to the detriment of the party represented by counsel. And in that case, the court found a pro se litigant had not stated a proper demand for relief and dismissed their claims. Now, in this case, the pro se litigant's letter nowhere references, a request to vacate the judgment. It nowhere requests to rescind the settlement agreement. Those requests and those statements are not contained in the letter anywhere. Furthermore, as the judge recognized below, in the context, it's clear that what the appellant was doing was responding to Judge Stargell's imposition of the injunction. The letter was submitted 5 days before a scheduled return hearing on the injunction. It is labeled a request for criminal investigation response letter to Judge Stargell. And in the only concise request for relief contained within the entire letter, the appellant requested 3 things: to visit the ward, to check on him by phone, and to communicate with his caregivers. These requests go to the terms of the temporary injunction. They cannot be properly construed, even under a liberal pleading standard, to be a request to vacate the judgment and rescind the settlement agreement altogether. Now, it's also worth noting that although the appellant was pro se at the time she filed the letter on February 19th of 2020, she retained counsel by March 3rd of 2020. And that counsel represented her all the way until July 17th of 2020. He appeared on the record in hearings and filed pleadings on her behalf. And at no point in time did he argue her letter was requesting to vacate the judgment or rescind the settlement agreement. And on the record, he repeatedly requested continuances of the evidentiary hearing and more time, and stated on the record that the appellant was accepting of the temporary persistence of the injunction for the time being. So he never raised the argument while he represented the appellant. She then retained new counsel on July 20th, who I believe may still technically be counsel of record. That lawyer also never argued that her letter was a Rule 1.50B motion for relief. He never raised his hand and said the appellant was arguing that the settlement agreement should be rescinded and the judgment should be vacated. Those arguments weren't raised. It wasn't until the ward died, 2 months after the ward's death, that the appellant's counsel, actually then her 4th counsel in the case, current counsel in this appeal, argued for the very first time that the letter was really a Rule 1.50B motion for relief. Now, the appellant's claim in their reply brief at page 6 that the fact that the appellant filed her letter in the guardianship proceeding and not the trust action, where the only judgment was actually entered in these proceedings, was actually correct, based on a provision in the settlement agreement that provides that if the appellant wishes to enforce her rights under the settlement agreement, she must file in the guardianship proceeding. Well, if the appellant was attempting to enforce her rights, then she couldn't have been rescinding her rights or attempting to vacate the judgment so that her rights under the settlement agreement went away. So the appellant is really attempting to have it both ways with that construction. The letter was filed in the guardianship proceeding in response to the injunction, and it should not be construed as a Rule 1.50B motion for relief, even under a liberal pleading standard. Now, second, even assuming the letter was a Rule 1.50B motion, the trial court correctly determined that the letter didn't present a colorable claim for relief. Now, at one point, appellant's counsel stated that a verification under the law wasn't required, and that is their position, that it wasn't required here, that the appellant could file an unsworn letter and that could be sufficient. But at the hearing on the motion to set, appellant's counsel at page 131 of the appellant's appendix conceded at the hearing that an affidavit or verification is needed when the motion is not based on the record. Now, I heard appellant's counsel say just now that the part of the record that is the basis for their claim is the letter itself, which is unsworn and therefore can't be the basis for the claim, coupled with the settlement agreement, the final judgment, and then the order on the injunction. That is apparently the entire corners of the basis of their claim now today to relief. And if that is true, that is insufficient under either B3 or B5 to state a colorable basis for relief. And this court does not need to spend the unnecessary time and expense of remanding the case back to the trial court for a full evidentiary hearing on the appellant's insufficient allegations. Now, the only contention in the letter, the crux of the appellant's claim, is contained at paragraph 37, which is in appellant's appendix at page 42. In paragraph 37, the appellant states, the only thing promised under this settlement agreement approved by the court was, quote, unlimited access to Pete in these last final months. And then she goes on to argue that the ward's attorney and the guardian, but not the appellees, engaged in some sort of threat of extortion and promised unlimited access to the ward in exchange for her signing the settlement agreement. Now, there's multiple problems with this contention and the ultimate basis for that component of their relief. The first problem is one that multiple members on the panel have recognized here, and that is that the letter, the promise of unlimited access is not contained within the settlement agreement. There is no promise of unlimited access contained in the settlement agreement. That's simply incorrect. And the appellant's belief and hope of what she hoped would happen after she signed the settlement agreement is not a basis to undo the settlement agreement and the judgment here. More importantly, just taking a step back, even if that provision wasn't in the agreement, this isn't just a contract case. A guardianship court, as this court well knows, has not only the power, but the obligation to take whatever actions are necessary in the best interest of the ward. In this case, Judge Stargel used his equitable power to prevent the appellant from having contact with the ward because it was in the ward's best interest to have no contact whatsoever. Judge Stargel entered that order in light of the settlement agreement, which he had reviewed and approved in camera before its entry. And the contention that the appellant could be promised that the court and the ward's fiduciaries, his attorney and his guardian, would never take actions that could prevent her visitation and communication with the ward is inconsistent with the equitable powers of the fiduciaries and the guardianship court itself, not just the terms of the settlement agreement. Now, additionally, we think it's significant that nowhere in the letter, the only document in the record that this court can consider, does the appellant argue anywhere that the appellees engaged in any misconduct. There is no contention in the letter itself. Now, the appellees in their reply brief at page 13 contend that in the trial court, the appellant alleged that the appellees participated in the alleged threat. But if you look at the citation to page 13 of the reply, it simply cites to the motion to set that the appellant's current counsel filed, which is simply unsworn lawyer statement asserting that the appellant had argued that the appellees engaged in extortion, and that obviously is not sufficient. And this court's decision in Castile recognized that the specific allegations of fraud that are needed to provide a colorable basis for relief under B3 require allegations of misconduct by the adverse party. There is no allegations of misconduct by the adverse party, and it would be unjust to vacate the judgment based on alleged allegations directed to a guardian and the ward's attorney, who are frankly not even parties to this litigation at this point and are not relevant to the continuing operation of the settlement agreement, which has nothing to do with the continued care of the ward because the ward has passed away. And The Rule 1.540B specifically provides that the court may only vacate a judgment on a motion and quote, under terms that are just. And it would be unjust to vacate the judgment and rescind the settlement agreement based on allegations of extortion that the appellant only raised after an injunction was secured by the ward's attorney, not even the appellees, after review and the careful consideration by Judge Stargel.
Didn't they join in the, I thought they filed something joining in the request for in the petition for the injunction. Didn't
Your
I see
Honor,
that? I'm sorry.
Your Honor, I'm sorry, Your Honor, the ward's attorney is the party that actually filed the emergency motion for temporary injunction. The appellees did join in the motion, but it was the ward's motion. And the ward's attorney's motion, and it was the ward's attorney who submitted an affidavit in support of the motion for temporary injunction. Now, third, the trial court correctly rejected what was really the crux of the appellant's arguments at the beginning of her argument today, and that is the mere fact of the imposition of a temporary injunction was a post-judgment inequity justifying vacation of the judgment. And you'll note, importantly, that at no point in the argument today, at no point in the briefs filed before this court, and at no point in any sufficient supported capacity in the trial court below, has the appellant ever contested the substantive basis for Judge Stargel's exercise of his equitable power to prevent the appellant from having contact with the ward. There is no allegation that the injunction was not entered for an appropriate reason. There is no allegation that the appellees somehow colluded with the ward's attorney or the guardian to drum up fake reasons to have an injunction, or there was some pre-agreement to get her to sign the settlement agreement and then yank away her ability to see the ward. There's none of those allegations in the letter, in any of the argument before the trial court, and in any argument here. It's simply the fact of the injunction that the appellants say is a post-judgment inequity, but the appellants haven't cited to a single case for the proposition that B5, which is to be narrowly construed, can provide a basis to vacate a judgment when a trial court exercises its equitable power to protect a ward from the actions of an appellant who was, in Judge Stargel's finding, possibly creating the possibility of violent outbursts that could affect his liberty and his condition. And the appellant cannot now argue that the exercise of equitable power creates a post-judgment inequity. There's no case for that proposition. And again, B5 in particular is recognized to be narrowly construed to preserve the finality of judgments and only provide extraordinary relief in the most exceptional of circumstances. Now,
Ms. Purdy, the appellant's sort of a catch-22 for them, isn't it? Because if they did challenge the factual basis for the injunction, that would strengthen your argument that the letter actually was a challenge to the injunction as opposed to a 1.540. So they're kind of stuck in that regard, aren't they?
Well, no, Your Honor, because they could have challenged it. Now, the letter was submitted on February 19th of 2020. According to the hearing on the motion to set, the appellant had 7 opportunities before the ward died to have a return hearing or to in any way request that the terms of the injunction be terminated, modified, or otherwise dissolved. And the appellant never took any steps to do that. Now, I know the appellant says, well, COVID was going on and we wanted to protect the ward from the possibility of being exposed to COVID by in-person contact. But as the appellant noted, the injunction dealt with other issues besides in-person communication. There was also a prohibition on speaking on the phone. The appellant never sought a return hearing contesting the factual findings in Judge Stargel's order and seeking to have some modification to the injunction while the ward was alive. Instead, she waited until 2 months after he died, after the court could actually make an appropriate finding as to what the health and welfare of the ward would be served if the appellant had contact, to even raise this argument that the injunction was somehow a post-judgment inequity. And again, the appellant has never argued and still doesn't argue today that the injunction wasn't entered for a proper purpose. They don't argue that. All that they're arguing is the simple fact of its existence is a post-judgment inequity. And there's not a single case that we have found, and there's no cases cited in the appellant's brief, for the proposition that the exercise of equitable power creates a post-judgment inequity. And again, the appellant's contention that she was promised this unlimited access, as paragraph 37, is belied by the powers of the court in the guardianship proceeding and the plain language in the settlement agreement. And so it cannot be that that contention does not provide a colorable basis for relief from the judgment, and isn't even really a plausible allegation. Now, finally, the last point briefly, Your Honors, is that the appellant argued that the memo of law wasn't considered by the trial court as some additional or standalone or related Rule 1.50B5 motion for relief, and therefore the trial court erred in its ruling. Now, that argument wasn't actually asserted until the appellant filed its motion for rehearing, which is, again, the subject of a separate appeal that is still pending and the briefing hasn't closed. But more importantly, the record reflects that the memo of law was never articulated to be its own B5 motion. In the court's order, it specifically referenced that it had reviewed the motion to set and the memo of law in reaching its ruling. The court also specifically, or the motion memo of law itself also specifically notes that it was requesting an evidentiary hearing on the pro se litigant's February 19th, 2020 filing. And if you look throughout the memo of law, it nowhere affirmatively states that it is a Rule 1.50B5 motion for relief, or even alternatively, that if the letter is deemed insufficient, the memo of law should be deemed to be its own standalone motion. So that argument wasn't raised, and it is the subject of a separate appeal, and the record supports that. But regardless, we know that the appellate court fully considered what is the crux of the appellant's argument below and the argument that they have made today, and that is the injunction is the post-judgment event that creates an inequity justifying the relief from the judgment. We know the court considered that argument. At the hearing, it stated it reviewed the memo of law. Its order acknowledged it reviewed the memo of law and considered it. And immediately before the court took the case under advisement, it asked the parties to provide it with a copy of the settlement agreement so that it could be considered in light of the appellant's argument that the imposition of the injunction rendered the appellant's rights under the agreement illusory. And that's in the appellant's appendix at page 192. So again, it was fully considered. And appellant's new argument that it was its own separate motion that wasn't considered by the court is contradicted by the record and was not raised until the motion for rehearing. So again, the panel, the principle of finality means something. Rule 1.50B means something. A party is required to present a colorable entitlement to relief before they get to an evidentiary hearing. And there's an important reason for that policy, and it's to protect the finality of judgments, the sanctity of contracts, and parties' agreements to settle what, as in this case, expensive protracted litigation. The appellant never filed a Rule 1.50B motion for relief in her letter. The other filings submitted by her counsel and argument below and today does not present a colorable entitlement to relief under Section B3 or B5. At bottom, the appellants would like this court to undo a judgment and exercise its equitable powers. Because Judge Stargel, reviewing the evidence and understanding the parties litigating in that case, exercised his judgment to protect the ward and his well-being from the appellant. And for those reasons, we ask this court to affirm the judgment of the trial court.
Thank you, counsel. You have your 3 minutes, counsel, for rebuttal.
Thank you, Your Honor. Turning to the issue of whether and when B5 was raised, I would point this court to A22, which is the motion, which states that alternatively, the motion for relief constitutes a timely Rule 1.540 motion seeking relief from the partial judgment and final judgment and rescission. And then it says specified in Rule 1.540B4 and 5. Now, we did drop I'd also point the court to the memorandum at pages 107 through 108, where we expressly rely on Rule 1.540B5, discussing the conduct of an adverse party, providing grounds to vacate the judgment in the settlement. At the hearing at 122, Appellee's counsel stated that the only issue is to schedule a hearing and to determine under Rule 1.45B5 and B3. At that same hearing at A140, Appellee's counsel recognized that B5 was at issue and stated, "What I heard today was that counsel for Ms. Beatty only is interested in Rule 1.540B5, and later stated that the pleading mentions Rule 1.540B3, B4, and B5. Again, that's the initial brief appendix at 140. And finally, at 222 of the appendix, the order does acknowledge that B5 was at issue. So that is all before the rehearing. As for the involvement of the appellees, as Your Honor did point out, the appellees did join in the temporary injunction. Also, if you look at the record at A27 and 28, it does discuss the fact that Pete's sons, that's how they're referred to, were part of threats to prevent and Ms. Beatty from seeing and communicating. And there's other allegations on those pages related to the appellees. Turning to the guardianship versus the trust action and the filing, this was raised before the court. Just to be clear, the settlement agreement, paragraph 11 at the sealed appendix 13 and 14 does state that this paragraph, which was the visitation and information paragraph, may only be enforced by motion in the guardianship proceedings. And my client had standing to the limited extent necessary in the guardianship proceeding to enforce that paragraph. So that was expressly agreed to in this, as set forth in the sealed appendix. It's not surprising accordingly that that's where the letter was filed. But even if that wasn't the case, once the appellant did retain counsel, the motion to set the hearing and the briefing schedule and the memorandum were filed in both proceedings, and that's at A21. And then finally, when the trial court did hear argument, the trial court stated that it was acknowledged both case numbers. And so that was at A1116. So any issue regarding where it was filed not only complies with the settlement agreement, and truthfully, if she had filed it in the other proceeding, they would probably, we would have an issue there too. So as Your Honor said, it's a catch-22 on either. We have preserved it. It was filed in the correct place according to the agreement, and later documents were filed in both proceedings.
I thank you, counsel, as we've well gone past the 3-minute mark. So at that point, we will conclude this proceeding. We thank you for your presentations today.
Thank you, Your
And
Honor.
I guess this court is now in recess. And for the panel members, if you will check your teams,